The hearing will start now. This is originating application 378 of 2023, Defi Payments Pte. Limited.
Good afternoon, Ms. Sheila Ang, Mr. Tejapranoto, and Ms. Naomi Lim for the applicant.
Good afternoon, Your Honor.
All right. And for the non-parties, Mr. Chua Swee Tong and Mr. Russell Ang.
That's correct. Good afternoon, Your Honor.
All right, thank you. I think it's all right for the other counsel present who are not speaking to turn off their video. Let me and Mr. resume elocution first. So parties are reminded that there is to be no photography, no unauthorized photography or recording in any form, and no dissemination of any photographs or recording of these proceedings. And only those counsel or person notified to the court should be present at each location, and parties should treat these proceedings as they would a physical hearing. Now, before we begin, a couple of things I'd like to reiterate. Firstly, we are at the stage of proceedings where any opposition or any arguments to be made against the applicants will need to be formally filed. So while I will not turn away any letters or petitions addressed to the court, I'm afraid I can't do very much on it unless the persons behind the letters or petitions actually proceed to file formal applications. And I would strongly suggest, given that we are at this particular stage of proceedings, that they will need, or they should actually consider instructing solicitors in Singapore. Now, following on from that, I will note that I have been given a petition addressed to my manager, titled Petition 5 in relation to false allegations of no creditor oversight of billings and liquidation, and this was sent in by Mr. Dorfeld. It's a short statement. Unfortunately, well, the contentions here, I don't think, from what I can see, germane at least to the calling of the scheme meeting as such, although it might be relevant in relation to the comparison between the scheme and liquidation. But I would just like to bring to everyone's attention, to reiterate to everyone's attention that really any arguments against the calling of the scheme meeting, any arguments eventually if the scheme meeting votes go through against the sanction of the scheme will have to be made by way of formal application supported by affidavits. So I'm afraid I cannot act on the basis of petitions as such. All right, Mr. Chua, before we continue, you're not acting for Mr. Dorfeld currently in this this afternoon?
No, Your Honor, I act for four mentioned in my notice.
All right. But anyway, for good record, I will instruct my manager to pass on the petition to both the applicant's counsel as well as the non-parties counsel, Mr. Chua and Mr. Ng. All right. Putting that aside, then let me then turn to the applicants. Thank you for sending your submissions earlier. Ms. Ang, you may highlight the main points of the submissions this afternoon.
Grateful, Your Honor. And with that, there are three parts to my submissions, which I will highlight. One that's in relation to whether leave should be granted to the applicant to convene a scheme meeting. Two, in relation to our prayer for a moratorium to lead up to the time of the scheme effective date, assuming that leave is granted to convene the meeting and also sanction is granted. And also the third part is in relation to how we envisage the scheme process, the scheme meeting and the POD process to be carried out. We are now turning to the first part, which is whether leave should be granted. There are various issues to be considered by the Honourable Court today. One in relation to whether there is a proposal before the Honour that has sufficient particulars to enable the court to assess if the proposed scheme is feasible. Two, in relation to the classification of creditors. Three, whether there is a realistic prospect of the scheme receiving the requisite approval at a scheme meeting. Four, whether there is any allegation of an abuse of process. And five, the issue of disclosure of all material information to assist the court in determining how the creditors' meetings to be conducted. Turning to the first point, Your Honor, in terms of the overview of the scheme has been set out in quite detail, and this will be in the first affidavit of Mr. Darshan Bhatia, and this will be at tab 3, page 58 onwards of the affidavit. I don't propose to take Your Honor through every single page of the scheme of arrangement, but what I would wish to give Your Honor today is an overview of the scheme. One, the scheme contemplates a distribution of the company's assets. The company's assets can broadly be categorized into liquid assets and illiquid assets, with the liquid assets being distributed quite quickly in the event the scheme is sanctioned. In terms of every distribution, it is contemplated that one, a certain amount will be set aside for a reverse Dutch auction process. So this is to facilitate any creditor wishing to exit the scheme early. They can put in a bid for payment out of the RDA assets, so the amounts that's set aside for this RDA process, and give a discount on their claim. The balance unutilized RDA assets plus the assets that are set aside specifically for pari passu distribution to all other creditors will then be distributed. This is in relation to the distribution of liquid assets. Insofar as illiquid assets are concerned, it may take some time depending on when these assets are recovered. And the same thing in terms of the process, once there are assets that come in, an RDA process will be contemplated if it's appropriate or not, depending on the timing as well as the quantum of recovery. And then also similarly, there will be an amount that's set aside for pari passu distribution to all creditors. So that's how it's contemplated in terms of distribution of assets. When it comes to the recovery of illiquid assets, the management will undertake the recovery process, and this is also set out in the scheme of arrangement, with supervision to be given by the scheme manager, reporting to be done on a regular basis. I should also highlight that in relation to the distribution and RDA process, there might be some tweaks to the current drafting of the scheme of arrangement, having taken into account creditors' feedback over the last couple of weeks. But the essence of the process remains the same in terms of RDA plus a pari passu distribution. In addition, it's also contemplated that the company will undertake a new business in decentralized finance yield generating strategies. But this is not something that is confirmed. This is subject to the approval of a new board to be constituted. As part of the scheme, it's envisaged that a new board of directors will take over, and this new board will then decide on the way forward in relation to any new business. One last element of the scheme is that of Defi Payments, the debtor, procuring Flipboat. So Flipboat Technologies, as Your Honor may recall, is an Indian entity which runs the trading business. And there are creditors of Defi Payments who are also creditors of Flipboat in relation to the INR balances. Under the scheme, it's contemplated that Defi Payments will procure Flipboat to satisfy the liabilities owing by Flipboat to its own creditors. This is about 2.5 million USD in case. The INR creditors, as I term it in short, will receive from Flipboat. This depends on whether there are assets available to Flipboat, because a lot of its monies, or rather all of its monies, are currently frozen in India. And if there are no assets available to Flipboat, it is also contemplated as part of the scheme that Defi Payments will make a loan of up to USD 2.5 million to Flipboat to satisfy this liability. And so with that, Your Honor, it's submitted that there is sufficient particulars to enable the court to assess if the proposed scheme is feasible. The overview of the scheme also is similar to the broad terms that were placed before creditors in the earlier months leading up to this application. And there was also a informal poll that was taken with creditors in February 2023 in relation to whether creditors might prefer a restructuring or a liquidation in that context. Going on to classification, Your Honor, this is the test is whether the creditor's rights are so dissimilar to each other's that they cannot sensibly consult together with a view to their common interest and therefore should be in a different class. It's contemplated here that there's only one single class of creditors, and these are all unsecured creditors of DeFi payments. Insofar as the concern is that, as I understand from my learned friend's submissions that have been filed, that there are concerns in relation to the creditors who are also flip-book creditors and therefore should be in a separate class. Our submissions, Your Honor, and this is also set out in our written submissions, is that it's properly classed as one class because insofar as the INR creditors' rights are concerned vis-a-vis DeFi payments, they are the same as any other creditor who are not owed INR balances by flipbook. The recovery that's contemplated in relation to the amount and their claims as against DeFi payments is the same. And I should also highlight that.
Sorry, I'm not sure I follow that. Why is there no distinction between the two?
So one, there's no distinction because insofar as a DeFi payments creditor's rights against DeFi payment is concerned, it's only in relation to their claim as a creditor of DeFi payments. And whether I am an INR creditor or I am a non-INR creditor, I will be getting the same percentage of recovery on my claim against DeFi payments.
True, but do you get some other benefit, potentially some other benefit under the scheme once it takes effect in this way? So isn't that a separate benefit under the scheme?
Yes, Your Honor. So, and that's in relation to an interest in terms of the potential recovery that these creditors might get. And that's where my submission, Your Honor, is that they're not so dissimilar. One, in relation, if we look at the number, USD 2.5 million is contemplated to be given as a loan. This doesn't change the total assets of DeFi payments, although we recognize that it changes the nature of the asset from a liquid asset to an illiquid asset, because then it becomes a receivable owing from flipbook. Therefore, it affects potentially timing as well as the recovery extent. For then
yes, so isn't that sufficient to make it to create a distinction?
Your Honor, and that's where my submission is that under the terms of the scheme, the rights of the DeFi payment INR creditor is not different because insofar as the terms of the scheme provide, it's an entitlement of DeFi payments if they wish to do so to give a loan. And if they don't do so, the right of the creditor vis-a-vis DeFi payments is a breach of the scheme of arrangement. And then therefore that simply means that the scheme will come to an end. It doesn't make it different vis-a-vis a non-INR creditor.
But vis-a-vis these INR creditors, I'm not sure I really follow your arguments that there is no distinction. Every time you say all these things, I keep seeing a distinction between their position and that of the other creditors.
Yes, Your Honor, I appreciate that. And maybe what I can then do is to break it down. So one, insofar as the INR creditors are concerned, they are getting the same amount on their DP claim. So if, and it's contemplated that there will be an average of 96% recovery, that's the same 96% that everyone will be getting, insofar as their claim against DP is concerned. The amount that's owing by flipbook is a different amount owing by a different party.
Yes, but why does that matter? They're still getting through this scheme, going forward, a additional benefit. So isn't that enough to influence the way they think about the whole situation? And isn't that then enough to actually mean that they have different interests from the rest of the creditors?
That's right. And maybe then I take it to the next level, which that even if that's the case, it is not so dissimilar. And it's not so dissimilar because the amount that we are referring to is only USD 2.5 million vis-a-vis the net, so the total liability of DP, which is more than 300 over million USD. So therefore, any recovery, and USD 2.5 million
Even if it's small, then I don't see what's the harm in carving them out into a different class.
Yes, Your Honor. And we have taken the position that they are properly one class, but we are guided by Your Honor. And if, I mean, what we can do is to take client's instructions on whether we proceed with two classes instead.
All right, carry on.
Heading to the next point, Your Honor, in relation to realistic prospect, we refer back to the informal vote that was done in February 2023. And this is set out at page 332 of Mr. Darshan Bashir's first affidavit, where 72% of the respondents in value indicated preference for a scheme. And it's our submission that this shows that there is a realistic prospect of the scheme passing at the meeting. Going on to the next point in relation to abuse of process, there is nothing to suggest at this point in time that there is any abuse of process. And on the contrary, the company has gone through the process of restructuring in identifying what's an appropriate restructuring mechanism, placing it before the creditors, taking comments, and coming to Your Honor today for leave to call on scheme meeting. Taking the adequate disclosure points, the drafts of the various documents, the explanatory statement, as well as the scheme of arrangement, as well as the scheme protocol have all been set out in the affidavit from pages 92 onward. In particular, the explanatory statements at page 92. And within the explanatory statement and the affidavit, the expected recoveries, the difference in recovery rates, the cost of the scheme, as well as the elements of the scheme have all been set out. If Your Honor wishes me to take you through them. Thank you, Your Honor. The financial position of the company has also been set out, and this is at page 102 of Mr. Darshan's affidavit and page 154. In particular, there has been concern raised about the identity of counterparty A, and maybe I can just deal with this upfront here. So counterparty A has been known to creditors that there is an existence of such a receivable of $179 million. We are unable to disclose the identity because of ongoing arbitration proceedings, and therefore the confidential nature of that, as well as the non-disclosure agreement between parties. However, whatever the information that can be shared has been shared throughout the restructuring process right from day one, back in July 2022. And in particular, the explanatory statement, if Your Honor can turn with me to page 104. And this is paragraphs 5.6 onwards. You set out there the discussion about the illiquid assets of the company. And at 5.7, we highlight the risk in relation to the recovery of the illiquid assets. In particular, at 5.7, Your Honor, at the end of the third line, the counterparty A assets are contractually due to be returned by June 2023. Counterparty A has initiated related arbitration proceedings against Mr. Darshan Bashir, which are pending. And we understand it's reasonably arguable that he has an entitlement to the return of the assets by June 2023. A discussion also on the status of the recovery of the other major illiquid assets is also set out in the same paragraph. So information to the extent that a company can disclose has already been set out. And over the course of the last couple of months, there have been various town halls, slides, creditor slides that have been issued. And these are all set out in the earlier affidavits. Would Your Honor like me to take you through them or just broadly to?
Just indicate them broadly. Thank you.
Grateful, Your Honor. And with that, maybe I can just highlight to Your Honor where they are. So these are in Mr. Darshan Bashir's 7 affidavits. 7 affidavits. In the presentation slides discussing the counterparty A, also in Mr. Sanju's first affidavit, and these are all filed in OA 318, which are the company's Section 64 application. In relation to the FAQs and the Q&A, where, for example, creditors have asked if you can't tell me who is counterparty A, can you confirm that it's not Nexo, for example? And confirmation was given in that regard. There were also references to some other questions that were raised in relation to when the loan end date is, and that's set out in Mr. Darshan Bhatt's 8th affidavit. There's also reference in Mr. Darshan's 11th affidavit on OA 318 that the counterparty to counterparty A is Mr. Darshan Bhatt. So the information to the extent available has already been given. And what we can do is to also include more information in the explanatory statement to be issued, to give more information in relation to the counterparty A receivable, except that we are not able to give the identity because of the confidentiality issues.
So what information, what further information are you able to give?
So we're able to give basically highlighting what has already been identified in the earlier documents, which is that the counterparty to the counterparty A is Mr. Darshan Bhatt. We can also talk about what's the business of counterparty A. We're not able to identify.
So you're actually just going to try to bring together and highlight previously disclosed information. You're not saying you'll be able to give anything new, correct?
That's correct, Your Honor.
All right, Karen.
Perhaps just before I go on to my second part of the submissions, if I could go back to the issue of classification, I could just highlight to Your Honor the case of Wayan Electrical Engineering, and this is set out at page 13 of my submissions.
I'm aware, Wayan. I don't know how far you can take it in this situation. It's not just a numbers game. I need to look at the different interests and incentives, and that's going to be a very fact-sensitive exercise.
Yes, I appreciate that. So that's one in relation to the recovery. That was what I was going to rely on Wayan for, and I appreciate Your Honor's observations, and I will move on, and I'll take first. I'll respond to Mr. Chua at a point in time later. Going on to the moratorium, Your Honor, the current moratorium under OA 318 ends on 28th of April. We are asking in this application for 4 months from the date of the order, and this is to cover the period from the convening of the meeting up to the application for sanction and lodgement of the order for the scheme to take effect. We have set out in the timeline that it's going to take about 50 business days in relation to the actual timelines that we could identify, plus, of course, a buffer for the lead time for hearing. If I could take Your Honor to the scheme protocol. This is at Mr. Darshan Bhatt's first affidavit, page 197.
All right.
Yes, sir. And then I will also perhaps use this opportunity to take Your Honor through the proposed scheme meeting process. And this is set up in the scheme protocol, which Your Honor has in front of you. So we start from 12th of April 2023, and that was the day where we filed the application. But where we start in relation to counting the 50 business days is from item B, which is the hearing, assuming that the leave is granted. So this is the day the leave is granted is day D. What's then contemplated as part of the process is that a notice will be issued to all creditors to how to access a bespoke scheme website. Also, it will set out the details of the online meeting and how to access information in relation to each individual approved claims. And that's because under the, sorry, maybe it might be a little bit convoluted. Perhaps what I could do is take Your Honor through the scheme timeline first, and I'll go back to another document to tell you the process. I think that might be easier to use that. So this is contemplated here in terms of a notice to be issued. And then after that, in terms of our scheme meeting process, it's contemplated to have the meeting, an online meeting, the voting process, and also the administration process. And this takes us to an online meeting to be held by way of a live stream D+11. So we are going to give about 8 days notice for the online meeting. The online meeting, it's not a prerequisite for voting. So we are proposing, subject to Your Honor's approval, is to split up the voting and the scheme meeting. So this is more like an information session held virtually, so that we can tell everyone what the scheme is about, taking questions, answer them, and also then release a recording of the meeting to everyone so that they are able to view it later. And this is set out at item E. The administration period then runs concurrently, and that's in relation to the disputes of any adjudication or inspection request. And that's then set out at part 2 in the timetable from D+3 onwards. That's the timeline that runs. And over the page, the voting period is contemplated to start from D+16, which is 5 business days after the online meeting, to run for 5 business days to end on D+25. Subsequently, then post-voting, there will be some time that will be required in relation to the tally of the vote, verification, and then filing of an application for sanction, which brings us to D+45. Then D+45, then that depends on how many days will be the lead time up to a hearing and sanction. Thereafter, another 5 days for expectation of a sanction order and filing 5 business days. So total here in this timeline is contemplated 50 business days plus lead time for a hearing. So this is the amount of time that we are seeking in relation to the moratorium. Briefly going to the other, the rest of my submissions in relation to the moratorium is that there is a reasonable prospect of the proposed scheme working. There's also, as earlier mentioned, there is no allegation of any abuse of process. And also that this moratorium will be necessary in light of the legal proceedings and threats. And this is set out in Mr. Darshan Bhattacharya's first affidavit at page 37. And turning to my next part of my submissions, and this is assuming your honors with me to grant the company leave to convene a meeting. We are proposing that the meeting be done in a certain way. Your honor has the jurisdiction to grant these variations pursuant to section 210(1), section 210(3)(ab), and section 6814. Section 210(1) and 3AB of the Companies Act, and section 6814 of the order. Yes, Nana. And maybe I'll use the scheme protocol. If I could ask your honor to to keep Mr. Darshan's affidavit open at page 200, and also if your honor could to take a look also at the originating application. And this is at Annex A and Annex B. So, Your Honor, there are 2 parts that we are asking for, and that's one in relation to how the scheme meeting be held, and 2 variations to the appeal and inspection process. So taking the first one, and if Your Honor has page 200 of the affidavit open, the first feature of the scheme process that we have in mind is that instead of the physical meeting that is traditionally contemplated, instead it's being replaced by an online meeting, an administration period, and a voting period, where creditors vote by way of submission of electronic vote after the scheme meeting, after the online meeting, as we call it. And the online meeting is merely for provision of information and the taking questions and answers. And the reason for that is because of the global profile of creditors. It's not going to be feasible to have a physical meeting or a meeting where the time zones will be suitable for everyone across the globe. And therefore, the proposed solution is to have an online meeting, which will be recorded, and a recording will be made available to all creditors. 2, in relation to the administration period, this is where we are going to set out a time period for creditors to dispute their approved claims, submit any additional claims they may have, as well as for inspection requests to be made. As part of the proof of debt process, if I could ask Your Honor to turn over the page of the originating application to the next page, paragraph 7 onwards. So traditionally, creditors will be given notice to file a proof of debt. Instead, what the company here is proposing, that insofar as creditors are concerned, they will be taken to have filed a POD, and the POD amount and the approved claim will be based on their balance of their cryptocurrency held in their board accounts. And that's because in terms of the universe of creditors to be bound by the scheme, these are the unsecured creditors who hold accounts on the vault platform with cryptocurrency balances outstanding. So reversing it, they will all be deemed to have filed a proof of debt, and the approved claim will be put up online. They will be able to access it to see what is their approved claim amount. If they disagree with that amount, they can then file a dispute claim. And when they file that dispute, an independent assessor will then assess that dispute. In relation to the independent assessor, that's also something that we are asking Your Honor to approve, and that's in relation to Annex B of the originating application. And this will be in relation to the variation Regulation 5.3. This will be on the 8th page of the originating application. So instead of each individual creditor who disputes the claim appointing an independent assessor, we are proposing that one single independent assessor be appointed by the court to adjudicate all disputes in relation to the proof of debt claims, as well as any request for inspection. And the proposed independent assessor is Mr. Luke Fuller from Contempt. His CV is also set out in Mr. Darshan's affidavit. And this is at tab 8, page 334 of the affidavit. Going back to the scheme process. So after disputes are raised, the independent assessor will then assess the dispute. At the same time, also in relation to the release of information of creditors' PODs, if Your Honor has the Annex B to the OA open, this will be at the Regulation 3. The notice to be issued in relation to the POD. The variation being sought is that instead of the chairperson sending out the notice to submit PODs, instead the POD will be deemed to have been filed, and the list of creditors will be set out in a particular form. And this is where we're asking again for variations. The list of creditors to be issued to all creditors have to set out their name, their address, the amount claimed, and a brief description of the nature of the claim. The request by the company is that the list of creditors instead sets out a redacted form of all the creditors' names, the country of residence, the amount of their claim, and a brief description of the approved claim. A sample of it is in Mr. Darshan's affidavit at page 31 of the affidavit. Paragraph 63. And the reason for this, instead of having the full name set out as well as the full address, is for privacy reasons. There have been concerns that have been raised by the creditors and also by the company that if information is being released, there are threats that can be made in relation to these persons, because people will know of their cryptocurrency. So privacy is quite a big issue, as we have heard from various creditors. And that's the reason why the company is requesting that a redacted form, a truncated form of the information be set out. And the submission is that the information that is sought to be provided is sufficient for a creditor to decide whether to inspect and which POD to inspect. And since we are on this page in relation to the POD inspection, Regulation 4, we are seeking the variation in that any creditor who wishes to inspect the proof of debt fills in an online form. So I earlier mentioned that there will be a bespoke scheme website that will be set up. So this website will have links to the various forms, the claim forms that in relation to the dispute of the approved claims, 2 inspection forms. It will then also set out subsequently the voting forms as well. And for the forms, they are supposed to submit an inspection request. Under the rules, under the regulations, what is contemplated then is that the affected creditor whose POD is sought to be inspected can then decide whether he or she objects or agrees to the request. In the interest of expediency, we are proposing that all affected creditors are deemed to object, and it just goes straight to the independent assessor for determination of whether to grant the request for inspection. There are also requirements under the regulations for publication of the list. 1, the list of all creditors who file a POD, and also 2, the results of the adjudication. And this is Regulation 5152 over the page. And we are proposing that instead of physical copies of the list be provided, they all be made available on the scheme website, electronic. And just to complete, in relation to the variations sought to Regulation 6.2 and 7, over the page. So we're asking for a little bit more time. So in relation to Regulation 6.2, the independent assessor has 7 days. We are asking for 7 business days in light of potentially the number of disputes that might be raised. So we are asking for 7 business days instead of 7 calendar days. And the last one, Regulation 7, I've already dealt with in relation to the updated list. Coming back then to Annex A, in relation to the rest of the scheme process. So we've already dealt with the submission and adjudication of PODs. The last part in relation to the voting and tabulation of the votes is that the voting will be done over a period of time. So voting will open and will stay open for 5 business days. And then the voting will be done electronically through submission of a voting form, and samples of the form are also set out in the affidavit. And one other thing that we are also asking Your Honor to make a variation in order of is in relation to the requirements of the threshold for the approval of the scheme. Because Section 2103AB makes reference to creditors present and voting, either by way of proxy or in person at the scheme meeting. It is proposed that the universe of creditors to be counted as part of the vote are those who submit a valid vote through the scheme website. And I think the other thing to highlight also in the scheme in Annex A will be that the proposed chairperson of the scheme meeting is the scheme manager, proposed scheme manager, which is Mr. Jason Kadaji, Pro. I think that summarizes the main parts, the main elements of the scheme process and the scheme meeting. And with that, perhaps I could turn to Your Honor if there is any question.
No, that's right. Anything further?
Grateful, Your Honor.
Sorry, Ms. Ang, anything further after that?
Not at this time, Your Honor, unless Your Honor has any.
All right, Mr. Chia, let me stand down for about 5 minutes before I come back to you.
Yes, sir.
All right, we'll stand down. Thank you.
For this adjourn. We will resume the hearing now.
Grateful, thank you. Can I just check whether we
Yes, apologies, Mr. Chua. You can begin.
Not at all, yeah. May it please the court.
Thank you.
Your Honor seen my submission, so I'll stick to the main points. Your Honor would have seen that my clients are objecting to this application on the ground of non-disclosure of material information. And we have a separate objection in relation to classification. I'll come to that later. But our primary argument is that this application for leave should not be granted. And I'll try and be brief about this, Your Honor. As far as the legal principles are concerned, I think they're well understood. Your focus at this stage isn't on the merits, and I won't go there. What I am trying to persuade Your Honor is that the non-disclosure objection we're making is in the context of DeFi's obligation to provide scheme creditors with a minimum level of disclosure that's necessary to satisfy the court that these creditor meetings that they're asking to convene is possible. The fair conduct of that is possible. And our concern is also quite focused. We're not trying to make a generalized allegation of insufficient disclosure. Our concern is about the failure to disclose the identity of counterparty A, because that goes to a key feature of this key feature of the scheme. And just to step back from this a little while, the applicants here have chosen to construct a scheme with this distribution mechanism where you give liquid assets first and then the illiquid ones later. And for liquid assets, they have deliberately come up with this mechanism where you have an RDA, and there will be an RDA at the first stage. And this construct that they've come up with immediately introduces uncertainties for creditors, and it requires them to assess risk themselves. And what they've done, Your Honor, is to pitch this initial RDA as a feature that will be unavailable in a liquidation, and hence this is an advantage that the scheme offers over a liquidation. Of course, there are other features that the applicant says are distinguishing as well from a liquidation, but this is the one feature that will not be able to be implemented in liquidation because it will contravene the pari passu rule where you treat all creditors equally. So creditors are being told this initial RDA is going to give you an option for those with lower risk appetites to get out earlier, and those with higher risk appetites who can stay on and potentially get much higher returns. And in some cases, far more in excess than what their debts are. They could get up to 227% if all things go well for them. So basically, whether you participate or not in this initial RDA, and if you participate, what is your discount at which you bid? It will determine your recovery rate in the scheme. That's my first point. You know. This is the construct. It requires them to make that choice. The creditors cannot run away with it in the initial RDA. And my second point is this. Once you've constructed this distribution mechanism, you must, as a creditor of necessity, take a view on the recoverability of the illiquid assets. You can't run away from that. And the illiquid assets, 70% of the value is made up of the counterparty A loan. We know about the other two, it's flip vote and coin loan. So 70% of these liquid assets are tied up in the counterparty A loan. And so if you feel that this loan, the counterparty A, is likely irrecoverable, it would be more rational for you as a creditor to participate in the initial RDA, potentially also bidding at a higher discount. So you get out earlier, you wipe off that risk. So to be clear, Your Honor, before I move on to my next point, I'm not trying to persuade you at this stage whether this construct is fair or not. That goes to the merits of the scheme. I'm just trying to persuade Your Honor that at this stage, the question here is, have creditors been given enough information to make an informed decision about whether the scheme with this initial RDA as a key feature is in their interest? How do you vote for that? That comes to my next point, my third point, which is if you take out, I know Your Honor would have seen that it's a long scheme document. It's got many complexities. The risk disclaimers take up many pages. But if you don't tell me that one crucial bit of information, who is counterparty A, really, what is the benefit of these 300 pages at all? There's no point telling me you're in arbitration with counterparty A, that on our side, it is Mr. Darshan who is the other counterparty. I want to know who owes me this 140 million plus. And how do you assess the recoverability of a loan if you don't even know who the debtor is? I come to my fourth point, and I accept that the Court of Appeal has said, and Your Honor has also ruled on various occasions, that when we look at disclosure, it's always contextual. You will ask the question, what is reasonable in the circumstances? So what is the context here that I like to impress upon Your Honor? The first is this, that they have chosen to construct the scheme in this way, to give creditors supposed choice. Their choice in my submission, then has to be a real one. It's got to be an informed choice. The second is, if you look at the creditor profile here, I think we all understand this. Your Honor has been inundated with correspondence from around the globe. You've got 150,000 potential creditors, or at least people with an account with VOL, and they're going to be participating in this voting process from all around the globe. I think it's fair to expect you will have varying degrees of financial sophistication, varying degrees of even an understanding of the Singapore scheme process, despite all the efforts that have been made to educate them through the different forums. Minimal understanding, I would say, of Singapore insolvency laws, what you would get in liquidation, for example. So when you have a scheme like this and you've got a creditor profile like this, if you can't make it simple, you've got to give as much information as you can. This isn't a simple scheme, so you can't do that, but you must give them the information they need to make that choice. And my third point is, given it's related to this earlier point of the creditor profile, you won't expect these creditors to have ever imagined that they would be in a situation today where they had to make these sorts of risk assessments. They thought they were putting money in a crypto deposit in a lending service. So they only had to assess DeFi as creditworthiness. And suddenly now, years down the line, their deposits are frozen. They're being told now, you don't have to just assess our creditworthiness, assess the creditworthiness of this party to whom you've given a substantial loan. But I won't tell you who that counterparty is. Is that fair, Your Honor? My submission, it's not. Now, Your Honor may also, I know that this is something that Your Honor would want to consider. Is really the right point to consider this question? Because could we not take it, for example, at the sanction stage after the Section 11 correspondence has gone out with the actual notices, actual explanatory statements? Your Honor, in my submission, this issue is going to come up regardless, because you already have before you a detailed explanatory statement that is more or less final. My learned friend mentioned that there might be some tweaks to this, but what will not be tweaked is this RDA process. And what will not go in is the identity of counterparty. We will face these questions again in the same form. And the same deficiencies will be there. Your Honor, I think my final point here on disclosure, and this is to respond to Ms. Ng's point that, look, the company has given all the information they can. We are barred by disclosure obligations, by both an NDA and arbitration from disclosing it. I mentioned this in my submissions, Your Honor. If that's the case, then don't put this feature in the scheme. You can't give people that choice and then tell them, I'm not giving you any information to make that choice. I think potentially an argument that they might make, and I haven't seen it made yet, but I think it's something that I want to bring up in case they make it, is this, that they might say, look, creditors can simply take this lack of information about counterparty into account in deciding whether the scheme is good for them or not. It's commercial risk. You take this uncertainty and then you just vote. My response to that, Your Honor, is this sort of uncertainty is not the same as uncertainty about, say, what the future might hold, how the litigation might pan out. I mean, those are all matters outside the company's control. This one is within the company's control and knowledge. It just says it can't provide it. And if this kind of answer is sufficient, that, you know, you vote on the basis of what information there is and you price in the uncertainties, my submission is that really it kind of undermines the whole principle of disclosure at this stage, because it sets this dangerous precedent where you can have that answer given by any company who gives insufficient disclosure and simply says, creditor, you vote, caveat emptor, you price this into your voting decision. Those are my key points, Your Honor, on counterparty. I know you've read my submissions, and maybe that's my primary position, that you shouldn't grant leave. And with that, Your Honor, if you have no questions for me on that point, maybe I'll move on to the classification issue. Your Honor, this one's a bit more straightforward in my submission. I don't need to ask Your Honor to turn up the scheme, but the flip vote payment is dealt with in clause 6 of the scheme at page 133. And I wanted to give Your Honor the reference because if Your Honor sees that clause, it will say that the company undertakes to pay for flip votes liabilities owed to INR creditors who are also creditors of DeFi. And I wanted to point that out because Ms. Ng had said, I think in a summary, maybe she misspoke slightly, that the obligation that our company was undertaking under the scheme was to procure FV to pay. If you look at the language of clause 6 of the scheme, it goes far more than that. The company is undertaking to pay those liabilities. And this is a right that the INR, or call them INR creditors, the INR creditors will acquire under the scheme that they will not have in any liquidation. This is a right that they acquire, it's not an interest. And I think the test for classification is quite well understood. You know, you look at the rights under the scheme, you compare that under rights against the most likely comparator if there's no scheme. And here there's no doubt that that comparator is insolvent liquidation. And so, in a nutshell, in this case, in an insolvent liquidation of DeFi, creditors with claims against Flipboard are going to get zero. That's clear. And they will have to look separately to Flipboard for the satisfaction of those liabilities. They've got no right to require DeFi to pay off at these liabilities. Under the scheme, as I just pointed out in clause 6, DeFi is not just undertaking to pay Flipboard's liabilities, but to pay them in full. And what is more, DeFi is undertaking to lend Flipboard money in order to fully satisfy those liabilities, which they are no obligation to pay in the liquidation. So in my submission, on any view, this gives the Flipboard creditors a huge additional incentive to vote in favor of the scheme, because it takes away all of their counterparty risk as far as Flipboard is concerned. They no longer have to be worried about whether Flipboard is going to be paying them. The company has undertaken to do that, using the funds from other DeFi creditors. Can I just briefly then respond to some of the points that were in my learned friend's submissions? And I think she also mentioned them already. The first is this reliance on Your Honor's decision in Bright Oil, which was dealing with lockup agreements. I think she was trying to make, the applicant was trying to make the argument that this is kind of akin to the incentives you get under lockup agreements, and Your Honor has ruled that lockup agreements in principle are not, don't fracture a class if certain requirements are satisfied. But I think it's quite clear that we're not talking about anywhere close to a lockup situation. For example, in Bright Oil, Your Honor had found that in that situation, the lockup agreement, those incentives were offered to everybody. And so everybody could avail themselves of that benefit. Clearly not the case here. And I think Your Honor had also said earlier that you made the point that you don't just look at the number. It's a matter of context. I think the context, the important context here is these Flipboard creditors get paid in full. They get paid, they clear off the counterparty risk from Flipboard, and they get a loan from DeFi to do that. The other point that was made by my learned friend was that in her submissions in her written submissions was that there's no ultimate difference in DeFi's net asset liability position. I think the way it was framed was, look, because the money that is lent to Flipboard by DeFi is simply going to be part of liquid assets, illiquid assets to be recovered from Flipboard. I mean, with respect, I think that's a slightly perverse way of looking at this, because Flipboard is currently under investigation by the Indian authorities. And those Indian authorities have frozen Flipboard's assets. And those assets would include sums which are due by Flipboard to DeFi. The owner may recall that DeFi, that there's actually a sum about 19 million US that is due and owing by Flipboard to DeFi. It's part of the illiquid assets. So what you're actually proposing to do here through clause 6 of this scheme is to increase that illiquid asset, that receivable from Flipboard, by another 2.5 in circumstances where Flipboard is already in difficulties with the Indian authorities. And so under the scheme, what you're going to have to do, or what DeFi creditors are going to have to do now, is to shoulder this additional burden of the risk of this 2.5 million loan, and you convert a liquid asset, your $2.5 billion in cash, to illiquid assets, and the recoverability of that is obviously uncertain by the company's own admission in their scheme document. My final point is this. It's in relation to the argument that, look, 2.5 million, the difference in recovery is not very much. I'll be brief on this because, as Your Honor had pointed out, you don't look simply at amounts. But I think in order to even get that argument off the ground, we first need to know who the Flipboard creditors are. How many are there? How much of each of them owed by Flipboard in Indian rupees? We don't have any of that information. The reason that's important is because you might well find out that all these Flipboard creditors have substantial INR balances, but really negligible balances due from DeFi. And to such a scheme, to such a creditor, this feature of the scheme is actually going to make the world of difference. They're not interested in the RDAs, etc. This is the one that will clinch it. And just to round off, I'm done here. I just want to make a final point. Why one has to question why they have included this feature in the scheme where flip-book creditors get paid off in full. And really, I'm struggling to find an answer to this, apart from the fact that they want these creditors to vote in favor of the scheme. This was deliberately designed to get these creditors to vote in favor of the scheme. That may be a commercial interest, but then these creditors vote separately. They shouldn't be lumped with everybody else. Your Honor, those are my submissions. I'm happy to take any questions.
No, thank you, Mr. Chua. That's all. Thank you.
Yes, sir. Thank you.
Thank you, Ms. Ang. It's just all right.
Good friend, apologies for that in relation to the technical difficulties.
Are you ready to proceed?
Yes, I am.
All right. Thank you.
Your Honor, I'll take 2 points. One in relation to the CPA, counterparty A, as well as the point about classification. Going to counterparty A, the sum information is available to all creditors. And that is the extent of the information that can be disclosed because of the confidentiality obligations of the company. And that's really what we can do. Insofar as the, so we are constrained in relation to what a company can do. And if there are any particular questions that the creditors have in relation to counterparty A, we are happy to consider whether we can address them, short of identifying and breaching the confidentiality obligations. So that's one way that we have proposed that we could provide more information to the extent possible in the ES or at the scheme meeting that's contemplated to be held. That's in relation to counterparty A. And going to classification that's the issue of flip vote. I just wanted to clarify that I didn't misspeak in relation to the obligation on behalf of the company. So yes, we do appreciate that the wording of the scheme of arrangement itself contemplates or suggests that the payment obligation will be undertaken by DeFi Payments itself. However, that's a language issue that is currently being redrafted. The requirement, but the obligation here, and this is set out in paragraph 15A of the affidavit. If I could ask Your Honor to turn with me to that. This is the intention of the scheme, which is that the company will procure. This is page 8 of Mr. Darshan's affidavit. The intention always has been that it's the company who will procure flip vote to repay DeFi Payments creditors who are also flip votes creditors in relation of their INR balances. And this basically constitutes $2.5 million USD in total aggregate claims. And it's also consistent with the next clause in the scheme of arrangement, which my learned friend pointed out too, which is that to satisfy that obligation in terms of procurement, in the event that flip vote needs a loan, DeFi Payments will give the loan. So it's not a situation where DeFi Payments itself is undertaking to repay on behalf of flip vote, but it's a situation where it's flip vote itself as the debtor making payment to the creditors of flip vote, who are also creditors of DeFi Payments. I think that needs to be also set out clearly. It's not a situation where payment will be made, or rather a loan will be given to to flip vote to pay all of flip vote's creditors. That's not the contemplation. The contemplation here, it's only in relation to the payment of creditors who are both creditors of DeFi Payments as well as flip vote in relation to the accounts maintained on the vault platform. I've really dealt with the point about classification. We do hear your Honor's views, and perhaps just to sum it up, I think the furthest that I can take this argument is that really at the end of the day, in terms of the dissimilarity test, is whether the creditors can sensibly consult with each other. And we say yes in our submission, because even if we take into account the INR payments to be made by flip vote to these creditors, it's not going to change a lot. And that's because the total value of the INR claims is only USD $2.5 million. So therefore, looking at it from the perspective of a non-INR creditor, we are only looking at a recovery of, let's say for a change, of 0.8%. So as a non-INR creditor, as compared, if there was no loan to be given, they would get 0.8% more because it's a liquid asset upfront, as opposed to potentially less, depending on the extent and timing of recovery of that 0.8%. And therefore, it's not very different from an INR creditor, which is a creditor of DeFi payments for their cryptocurrency balances, as well as their claim against flip vote for the INR balance. And the total of that in aggregate of INR claims is only USD 2.5 million. So from that perspective of a creditor who has a claim against flip vote, compared to a 96% as against DeFi payments itself, even if I add 100%, it's no more than a differential of 3 to 4%, because it can never hit 100%, but it will be somewhere between 96 and 99.99%. And that, Your Honor, is my submission that it's not so dissimilar at the end of the day in relation to whether they can sensibly consult with each other. One other thing is that sorry, Your Honor, I think that's all my submissions at this point in time, unless Your Honor has any questions for me.
All right, thank you. Let me have a minute. All right, let me just stand down to about 4:15 to go through the papers and consider what my decision will be, and we'll reconvene at that point. All right, court stands.
Court is adjourned. Hearing will resume now.
All right, thank you. I will now give my decision. Now, I must emphasize that the test that governs at this stage of the proceedings does not, as Mr. Chua has noted, stipulate an assessment of the merits. The court focuses on matters that go really to disclosure and the proper deliberation of proposals and the prospect of the approval being given, as well as whether any abuse is likely to arise. Now, in the present case, the concerns raised by Mr. Chua do indeed need to be addressed, but not, I think, through a denial of leave to convene the meeting, provided the statements and other processes are appropriately amended. The identity of the counterparty is important, but I accept that there are bars to its disclosure. It does not follow, though, that the scheme should not be put to the vote because of this non-identification. It is sufficient at this stage, I think, for me to require that the explanatory statement highlight the information about the counterparty that is available and to indicate clearly in bold and a prominent part of the statement that the identity cannot be disclosed for the reasons stated by the applicant, but that it may nonetheless be important for some creditors in assessing the risks attaching to the scheme. So this needs to be put into the explanatory statement, and I should also specify that it should be highlighted in the meeting itself. I would also require, in relation to the classes, that those who are flip-flop creditors with INR balances to be classed separately. I do find that their interests are sufficiently distinct that they cannot sensibly be put together with the other creditors, and this is not just a question of range and recovery, as was the case in YN. I do approve the calling of the meeting provided on the basis of these amendments and further approve the various variations sought which are necessary to effect a meeting of this creditor size with a global distribution. Now, I also further direct that any complaints about the process should be logged by those administering the meetings and compiled and filed together with section application if we get to that stage. The moratoria is extended as prayed for, and thus, subject to these amendments, I would grant order in terms of praise 1, 2, 3, 4, 5, and 6 of the summons. All right, so Ms. Ang, these are my directions and amendments. I would take it your client wishes to proceed on this basis.
Yes, Your Honor, I've got all my client's instructions in the meantime, and yes, we will be happy to proceed on this basis.
All right, then. All right, anything further this afternoon, Ms. Ang?
Nothing from me, Your Honor.
All right, anything further, Mr. Chua?
No, Your Honor, not
All
for me.
right, thank you both for your submissions.
Great for you.
Thank you, Your Honor.
The court is adjourned. Thank you.
Court is adjourned.